Picture this. It is a beautiful Saturday afternoon. You have finally carved out, maybe 20 minutes to read that book you bought 3 months ago.
Right, a rare moment of peace.
Exactly. You sit down, open the first page, and then the walls start vibrating. Your neighbor has decided that 2:00 p.m. is the absolute perfect time for their death metal band to rehearse in the garage directly adjacent to your living room.
Oh, yeah. It's a classic suburban nightmare.
Yeah.
And honestly, it's a very common trigger for people to suddenly become highly interested in the legal system.
Right. Or let's raise the stakes a little.
Right.
You are driving to the grocery store, just minding your own business, and a delivery van with a massive corporate logo on the side, let's call it Speedy Delivery Inc., blows a red light and slams into your bumper.
Ouch.
Yeah. And you get out, and the driver is clearly just a teenager who was looking at their phone.
Both exceedingly frustrating situations, but also, both are perfect storms for legal analysis.
And that is exactly the question we are tackling today. In those specific moments, who is actually responsible? Like, can you legally force that neighbor to stop shredding on the guitar, or do you just have to give up and buy noise-canceling headphones?
Yeah.
And with the van, do you sue the kid who probably has no money or the giant corporation on the side of the truck?
It's a great question because, the answer usually stops being about what feels fair in an emotional sense, and it starts being about very specific structural rules of civil liability.
Exactly. So today we are doing a deep dive into the hidden operating system of civil responsibility. We aren't just looking at random laws here. We are looking at the actual architecture of blame.
The mechanics of it.
Right. And to do this, we've pulled a stack of really heavy-duty sources. We've got the jurisprudence and the multi-state bar examination guide and a specialized masterclass script specifically on torts.
Yeah, these are the texts that law students lose sleep over. This is the black letter law used to prep for the bar exam. So we are getting the real technical definitions today, not just the TV lawyer version.
Our mission is to unpack 3 specific buckets of liability that basically dictate how the world works. First, we're talking nuisance, the neighbor wars. Second, vicarious liability when you are on the hook for someone else's mistake. And third, allocation.
Which is really just a fancy way of saying who actually writes the check.
Well, exactly. Who pays the bill?
I love these topics because they reveal how society distributes risk. It's this unglamorous framework that holds everything together. It decides who carries the burden when things go wrong.
So let's just jump right into bucket number 1, nuisance. I feel like everyone uses this word casually, like my boss is a nuisance or this traffic is a nuisance. It just means annoying, right?
Colloquially, sure, but legally, absolutely not. If you walk into a courtroom and claim private nuisance, you have to prove something very, very specific. The definition in the sources is a substantial and unreasonable interference with another person's use and enjoyment of their land.
Use and enjoyment, that sounds distinct from someone actually coming onto your property.
Precisely. And that is the first big distinction the bar guide makes. You have to separate nuisance from trespass. Trespass is physical.
Okay.
Like if I throw a rock onto your lawn or if I walk across your backyard without permission, that is trespass. It involves a literal physical invasion of the land.
Okay, so a rock is trespass because it has mass. It takes up physical space. But what about the death metal band? Or, say, a terrible smell from a pig farm next door? Or really bright floodlights from a stadium?
Right, those are intangible. You can't hold a beam of light or a bad smell in your hand. Because they aren't physical objects invading the land, they fall under nuisance. They interfere with your ability to enjoy being on the land, but they don't physically occupy it.
That makes a lot of sense. But I want to drill down on those magic words you mentioned from the source, substantial and unreasonable. Because, let's be honest here, some people are easily annoyed.
Very true.
If my neighbor is cooking garlic and I just happen to hate the smell of garlic, that interferes with my enjoyment. Can I sue them for nuisance?
You can try, but you will almost certainly lose. That's where the word substantial does all the heavy lifting. The interference has to be more than just a trivial annoyance. The source material emphasizes that the standard is objective.
So it's not about me personally.
Right. It must be significant enough that a normal person in the community would be meaningfully bothered.
So the law literally doesn't care about my specific sensitivities.
Generally, no. If you are hypersensitive to smell or you have super hearing, that is your personal burden to bear. The law protects the average neighbor.
Okay, so that's substantial. What about unreasonable? That sounds incredibly subjective. Like, who decides what is unreasonable?
The courts do, and they do it through a really fascinating process called balancing. They essentially weigh the gravity of the harm to you against the utility of the defendant's conduct.
Utility, you mean like how useful the annoying thing is?
Exactly. The law asks, is the thing causing the noise or the smell actually good for society? Let's look at a classic law school example directly from the source material. Imagine a cement factory. It produces smoke, dust, and vibrations that shake the neighboring houses.
I mean, that sounds like a clear nuisance. It's substantial, it's annoying, it's obviously ruining the property value.
Right. But let's say that factory employs half the town. It produces the concrete needed to build the local roads and hospitals. It has a very high social value, high utility.
Ah, so the court is stuck. Do we shut down the factory to save the neighbors' clean air, or do we keep the factory open because the town desperately needs the jobs?
Yeah, exactly. And this is where the legal remedy gets super interesting.
Hmm.
Often, the court won't issue an injunction.
An injunction being an order to stop the activity.
Right, a stop order. They won't issue it because the utility is just too high. Closing the factory hurts too many people. Instead, they will find that the interference is a nuisance, but the remedy is damages.
Basically telling the factory, you can keep polluting because we need the cement, but you have to pay the neighbors every month for the hassle.
It sounds a bit cynical, but economists actually love it. It forces the factory to internalize the cost of their pollution. They have to pay for the harm they cause, which incentivizes them to maybe install better filters, but it keeps the business running.
Okay, now compare that to the death metal band in the garage.
Right. What is the social utility of a garage band practicing at 2:00 a.m.?
Unless they are literally the next Metallica, probably zero.
Exactly. So in that case, the gravity of the harm to the neighbors vastly outweighs the utility of the conduct. That makes it unreasonable. The court would likely issue an injunction and shut them down.
So nuisance is really just a constant balancing act between my right to quiet and your right to do useful things.
That's a perfect summary, yeah.
Before we leave this bucket, the sources also mentioned public nuisance. Is that just when a lot of people are annoyed, like the whole neighborhood hates the band?
It's a bit different. Public nuisance isn't really about quantity. It's about the type of right being interfered with. A public nuisance is an unreasonable interference with rights common to the general public.
Like what?
Things like public health, safety, or blocking a public road.
So if a factory dumps chemicals into a river that the whole town uses for drinking water, that's a public nuisance.
Correct. But here's the catch, and the sources really highlight this. It's called the special injury rule. Usually, a private citizen cannot sue for a public nuisance. That is the government's job. The Attorney General sues for public nuisance, not you.
Wait, really? So if the river is polluted and I can't swim in it anymore, I just can't sue?
Not unless you suffer a harm that is different in kind from the general public.
Give me an example of different in kind.
Okay, let's stick with the polluted river. Everyone in town suffers because the river smells bad and they can't swim. That is a general harm. If you sue just because you can't swim, the court will toss it right out. But suppose you are a commercial fisherman.
Ah, I see where this is going. I actually rely on that river for my income.
Exactly. The pollution kills the fish, and you lose your entire business. Your neighbor just lost a swimming spot, you lost your livelihood. That is a pecuniary or financial loss. It is completely different in kind from the general public's inconvenience.
And that gives me the standing or the right to actually sue.
Precisely. You have a special ticket to the courthouse that your neighbors just don't have.
Okay, let's shift gears to bucket number 2. And I'll be honest, this one scares me a little because I own a small business, and the idea of being responsible for everything my employees do is pretty terrifying. We're talking about vicarious liability.
Or as the lawyers like to call it, respondeat superior.
Let the master answer.
That's the Latin, yeah. The core concept is that an employer is liable for the torts, the civil wrongs committed by their employees. But, and this is a crucial distinction, only if those torts happen within the scope of employment.
This just seems like a massive risk transfer. You're telling me if I hire someone to drive a van and I explicitly tell them, drive safely, do not speed, and they speed anyway and hit someone, I'm responsible?
Generally, yes. It's based on the idea that you are the one setting the whole enterprise in motion. You are the one profiting from their driving. Therefore, you should bear the risks associated with it. Plus, practically speaking, you, the employer, usually have the insurance policy and the assets.
Right.
The driver probably doesn't.
So the law is essentially looking for the deep pockets.
We try not to say it quite that explicitly in law school, but yes, the law wants the victim to be compensated, and the employer is the best route to make that happen.
But the scope of employment tests limits that liability, right? Like, it's not just infinite.
Correct. It is not infinite. The sources break it down into three specific factors. To be within the scope, the act generally needs to be, 1, the kind of work they were hired to do. 2, it has to happen within authorized time and space limits. And 3, it has to be motivated, at least in part, to serve the employer.
Okay, let's apply this, because this brings us to my absolute favorite legal distinction in the entire stack of notes: the difference between a detour and a frolic.
I love these terms so much. They sound like something from a children's nursery rhyme. But that distinction literally determines whether a company pays millions of dollars or nothing at all.
Let's use the delivery driver example from the source. So I'm a driver for Speedy Delivery Inc. I'm on my route, but I get thirsty. I pull off the main road to get a coffee at a drive-thru. As I'm pulling out of the drive-thru, I hit another car. Is my boss liable?
That is a detour. It is a minor deviation from the employer's business. You are still generally within the time frame, you haven't gone far, and honestly, getting coffee keeps you fueled to do the work. The courts view this as incidental to the job. So yes, the employer is liable.
Okay, now, scenario 2. I am supposed to be delivering packages in the city, but I suddenly realize my best friend lives 40 miles away in the suburbs, and I haven't seen him in ages. I decide to completely abandon my route, drive 40 miles west to his house, hang out for 2 hours playing video games, and then on my way back to the route, I hit a car.
That is a frolic.
I have frolic.
You have absolutely frolic. You've completely abandoned the employer's mission. You are on a purely personal adventure of your own making. Because you've engaged in a major departure from your duties, you are officially outside the scope of employment.
So in that specific case, Speedy Delivery Inc. just says, not our problem.
Exactly. The employer is not liable. The victim has to sue the driver personally.
So the magic line is somewhere between a 5-minute coffee break and a 40-mile road trip.
It's a spectrum.
Yeah.
And courts argue about the middle ground all the time. But the key is always the intent to abandon the business of the employer.
Here's where it gets really interesting to me, though. What if the employee does something intentional? Like, not a car accident, but they actually punch someone. Surely the boss isn't responsible for that, right? I didn't hire them to punch people.
The general rule is you are right. Intentional torts, like battery or assault, are usually considered outside the scope of employment. If a receptionist gets into a heated argument about sports with a visitor and punches them in the face, the employer isn't liable. That's personal rage. It serves no purpose for the employer.
Right. But I feel like there's a but coming here.
There is always a but in law. The exception is when the job itself involves force, friction, or confrontation.
Oh, like a bouncer.
Exactly. If you hire a bouncer to physically remove people from a club, using force is literally part of the job description. If they use excessive force and, say, break someone's arm, that is considered foreseeable. It is within the scope of employment because you hire them to be physical in the first place.
So if you hire someone to be aggressive, you own the aggression.
Precisely. Foreseeability is the thread connecting all of this. If the friction is inherent to the job, like a debt collector or a bouncer, the employer owns the risk of that friction boiling over.
Now, what if I just don't want any of this liability? I decide I'm not hiring employees, I'm just going to hire independent contractors. Because the rule is generally that you aren't liable for contractors, right?
That is the default rule, yes.
Yeah.
Because you don't control how a contractor does their work. You just pay for the final result. You aren't responsible for their torts. It's a very, very common strategy to avoid liability.
But the sources list 2 massive exceptions where you cannot hide behind a contractor.
They do. You cannot outsource liability for nondelegable duties like the basic safety of customers walking into your store, and you cannot outsource liability for inherently dangerous activities.
Inherently dangerous. That sounds intense. What actually qualifies as that?
Blasting, demolition, handling high-voltage electricity. Activities that are so inherently risky that the law steps in and says, look, if you want this done, you are responsible for it no matter who you hire to pull the trigger.
So if I hire a completely independent contractor to use dynamite to clear some rocks on my land, and a piece of rock flies 3 blocks and hits a parked car,
you are liable. Even if the contractor was an entirely separate entity, the law says you cannot outsource the risk of dynamite. You started the dangerous activity, you hold the bag.
Okay, so we've covered the neighbor wars and the boss's liability. Now let's move to bucket number 3. Allocation. This is the splitting the bill part.
This is where things get mathematical and, frankly, where co-defendants start turning on each other.
Let's set the scene. Imagine a scenario where 2 different people mess up and it hurts one victim. Let's say a factory negligently releases a cloud of toxic smoke, and at the exact same time, a trucking company negligently spills harsh chemicals. The smoke and the chemicals mix together, settle on a farmer's field, and ruin the entire crop.
Okay, classic law school hypo.
The farmer has $100,000 in damages, but he can't possibly tell which plant was killed by the smoke and which was killed by the chemical spill. It's just one big mess. Who pays?
This brings us to the concept of joint and several liability. It applies exactly when there is an indivisible injury, meaning you simply can't separate the harm.
So can the farmer just go to the factory and ask for the whole $100,000?
Under joint and several liability, yes. The plaintiff can collect 100% of the money from any one defendant, even if that particular defendant was only, say, a little bit at fault.
That seems intense. If I'm the factory and I was only 10% responsible, why do I have to pay everything?
It's designed entirely to protect the victim. Suppose the trucking company is totally bankrupt, or the driver fled the country. The law says the innocent victim shouldn't suffer just because one of the wrongdoers is broke. The solvent defendant, the one with the money, has to cover it.
Okay, but that factory that just paid $100,000 is going to be pretty unhappy about paying for the trucking company's share. How do they fix that?
That leads to our next two concepts, contribution and indemnity. People confuse these all the time, but the distinction is absolutely vital.
Break it down for us. What is contribution?
Contribution is about sharing the bill. Let's say the factory paid the full $100,000 to the farmer, but the jury determines the factory was only 40% at fault, and the trucking company was 60% at fault.
So the factory overpaid.
Right. So the factory can then sue the trucking company for contribution. They can force the trucking company to pay them back for their 60% share. They are rebalancing the scales based on relative fault.
Okay, so contribution is, I paid it all, now give me your share. What is indemnity?
Indemnity is different. It's not sharing. It's shifting the bill completely. It's passing the buck 100%.
When does that ever happen?
Usually in vicarious liability cases. Go back to our speedy delivery driver. The company has to pay the victim because of respondeat superior. But the company didn't actually drive the car, right? The employee did. The employee is the active wrongdoer.
So the company pays the victim, and then
the company can seek indemnity from the employee. They can sue their own employee to get the full amount back because the employee was the one who actually caused the accident.
Wait, really? A company can sue its own employee to get the money back?
Legally, yes. Practically. Employees usually don't have $100,000 lying around, so it rarely actually happens.
Yeah.
But the legal structure allows the passive party, the employer, to be fully reimbursed by the active wrongdoer, the employee.
So contribution is like splitting the check because we both ate. Indemnity is making the other guy pay the whole tab because he ordered everything and I just sat there.
That is a perfect analogy, yes.
And there's one last rule here in the sources, the one satisfaction rule.
It's a simple concept. A plaintiff can only recover the full amount once. You can't get $100,000 from the factory and then go get another $100,000 from the trucking company for the exact same injury. No double dipping through settlements.
That seems fair. So we've been on quite a journey here today. We started with nuisance, understanding that just because your neighbor is annoying doesn't necessarily mean you can sue them. It has to be substantial and unreasonable.
And we saw how the courts balance the utility against the harm. It's not black and white, it's a sliding scale.
Then we looked at vicarious liability. If you employ people, you are generally responsible for them unless they go on a frolic.
Which is a major departure from their duties.
And finally, allocation. If multiple people caused the mess, the victim can get paid by whoever has the money, but then the defendants have to fight it out amongst themselves using contribution and indemnity.
It's a complex web. But when you step back, you realize these aren't just obscure rules for lawyers. They are the operating system for how we interact in society.
What do you mean by that exactly?
Think about it. These rules determine how careful we have to be. They determine whether a factory invests in expensive smoke filters to avoid a nuisance suit. They determine whether a delivery company tracks its drivers with GPS to prevent those frolics. They incentivize safety by literally putting a price tag on risk.
It effectively forces us to care about the people around us, or at least care about the cost of hurting them.
Exactly. It forces the internalization of costs. If you create a risk, the law wants to make sure you have a plan to pay for it.
This brings me to a final thought I want to leave you, the listener, with. We talked a lot about foreseeability today. The law seems to constantly suggest that if you can foresee a risk, like hiring a bouncer who might punch someone, or blasting dynamite that might hurt a neighbor, You own that risk.
Right. Foreseeability creates responsibility.
So here is the question for you. In your own life or your business or even just your side hustle, what risks are you accepting right now without even realizing it? Are you the employer whose driver is currently on a frolic? Are you the neighbor creating a nuisance but just convincing yourself it's okay? The law says you are responsible for what you should have foreseen. So look around. What should you be foreseeing right now?
That is the million-dollar question, sometimes literally.
Thanks for diving deep with us today.
It was a pleasure.